All right, we're now on to the law, court decisions, and the police. I'm briefly going to cover some of the things that are important and that police officers have to understand. What's really important to understand is police officers have to enforce the law. Therefore, they have to understand all the different laws out there. So I'm just going to cover a little bit of it now, and just to help you understand what law enforcement officers have to learn and be tested to ensure they understand and know about law during an academy, and then what they have to stay up to date on throughout their work with law, court decisions, appeals court, Supreme Court, so they know when things change because things are constantly changing. Okay, I'll let you know if something's important that you need to remember as well. Okay, so the parameters of police activity are governed by federal laws, state constitutions, federal constitutions, municipal ordinances, those are city ordinances, and court decisions. So officers of a certain area have to understand all those constitutions, laws, and court decisions. Okay, we have two basic types of law. We have criminal law and civil law. So officers are generally out there enforcing criminal law. If something is civil, generally officers will refer that person to a civil court proceedings. For example, landlord-tenant issues. If we go out to a call and somebody says, my landlord raised my rent. Or if we go out and a landlord says, my tenant hasn't paid rent. Those are called civil disputes. It's not something that law enforcement officers handle, and so it is referred to a court that does handle that, and it's civil in nature. All right, so first of all, laws are confusing. You go to law school and they spend time reading court cases and trying to understand them and understand what is meant. And different people will see the meaning of them differently. So it's really important for officers to really be able to read a case, understand what it says, understand what it means, and be able to have contacts with the different courts to be able to say, hey, I don't understand this. What does this mean? So that they aren't out there violating anybody's rights because of they misunderstood a court decision. All right, so determining whether or not a law has been broken is obviously a technical judgment. But again, like I said, the officer's not alone in making those decisions. And I remember I would constantly be calling our district attorney or city attorney saying, hey, how do you see this? Or what is this? Or what do you think about this? Because sometimes it is very difficult. All right, so, and this is just going on again, talking about how it's so important that the police maintain communication and contact with the attorney general, the state's attorney, district attorney, everybody, so that they understand the communication is open with what the law is and what the person accused of breaking the law did to make sure it falls under those parameters. And these are just some examples. You can pause here if you want. But for example, just in Ashland, we have a city attorney, and then there's a municipal court in Ashland, and then Medford has a municipal courts and city attorneys. And then these are just examples of, in Medford alone, dismissible traffic citations. So if you have any of these things going on with your vehicle, if you fix them, they can be dismissed. Medford also has a traffic school. So that's if you get your citation in Medford. If it's somewhere else, you go to that court to see what they require. Then just in Jackson County, under the circuit court system, you have the Supreme Court, Court of Appeals, tax court, circuit courts, local courts. You also have administrative hearing officers. All right, so you got a lot with the court system. So, and every county has their court system as well as some municipalities, depending on how big they are. All right, so let's go over the amendments that police officers have to be cognizant of. So first of all, we have the First Amendment. Not that they're not all important, but just I'm going to review the ones that officers come into contact with and have to really know and understand. So the First Amendment states that Congress shall make no law prohibiting free exercise of religion or abridging the rights of free speech, peaceful assembly, and the police are frequently involved in protecting these rights. You probably will see these amendments in a future quiz or test. So make sure you know these amendments we're covering. So police go out to athletic events, holiday parades, concerts, openings of controversial movies, because they want to make sure that people are obeying the law and that whatever they're doing to exercise their First Amendment right is legal and peaceful. All right, so, and again, they're making sure there's no hate speech, fighting words, obscenity, making sure everybody's safe and there's no danger. All right, we then have the Second Amendment, and that deals with the right to bear arms. And obviously, there's been a lot of considerable litigation with that. There's also the right to carry concealed weapons. So understand that there is a difference. So basically, certain states, not all 50 states, but most of the states have what we call open carry laws, which basically means that, and you can Google which states allow open carry, but it basically means that if you have a firearm that you have a right to legally own and you got it legal, that you can carry it openly, like on your body, in a holster, in a belt, if that state is open carry. Now, I don't obviously recommend that because you have a lot of people that are scared or don't know what you're doing with that. And so generally you'll see people open carry in a place such as a firearm range or something like that where they can legally do it. You also have states, not all, but some states, a lot of the states do allow what we call CCWs, which is concealed carry weapon, or CHL, concealed handgun license, which means if you go through a class, a lot of states require you have to actually qualify with the firearm. You can conceal that firearm on your person, hide it underneath clothing, or you can put it in a bag or something like that. And you have to be fingerprinted, and the county sheriffs have to know who you are and that you have that. And there's certain parameters of where you can also carry, because certain places you can't carry even a concealed handgun or open carry. All right, Fourth Amendment. We've already talked about probable cause and reasonable suspicion. So the Fourth Amendment says it's the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated. So we've talked about reasonable suspicion, which is Terry versus Ohio, which means an officer can stop, detain you. In Oregon, can detain you for a reasonable amount of time. That's around an hour. Is what's considered reasonable unless you have exigent circumstances that extend that time. And then probable cause means that the officer has a reason to arrest you, or you have evidence that can lead to the arrest, and the officer can fully search you. All right. We've covered, again, you can go back and pause on these if you want to cover what probable cause is, but we've already done that, and that's under the Fourth Amendment. All right, so searches and seizures without a warrant. So having a warrant is always recommended. So if an officer is going to want to go into somebody's house, they can't just knock down the door and go in. Same with somebody's car. That is just not good. You want to get a warrant. However, there are times where there aren't times to get a warrant, but the officer has to be able to prove that. So we're going to talk about those. So again, whenever possible, the officer wants to, or law enforcement should get a warrant, should write up, hey, this is my probable cause. I believe this person is selling heroin out of their house. We had a confidential informant buy at 3 different times the heroin. Here's pictures of that. We want to serve a warrant. And then a third party, which is the judge, reads all that, makes sure there's probable cause, signs off on it so that the person's Fourth Amendment rights aren't violated, so that just one law enforcement officer doesn't say, oh, I'm going to break down the door of this person. We've got to make sure there's checks and balances. So what we look for is the totality of the circumstances. So if an officer, there are times where an officer can legally enter somebody's vehicle or their home without a warrant, and or make an arrest. For example, we have what's called the plain view doctrine. So let's say that you were arguing with your roommate and your roommate hit you and you called the police. The police have a domestic battery incident. They have to come in to investigate. They come in and they see heroin on the coffee table. They don't have to get a warrant. They were there. They got called to investigate a domestic battery. They have to investigate that because of the laws. And they saw the heroin in plain view. So the person can't say, oh, you didn't have a warrant, you violated my Fourth Amendment right, because that's the plain view doctrine. All right, we also have police searches incident to arrest. So normally, obviously, a police officer just can't come up and pat you down or search you. However, if an officer has reasonable suspicion, like we talked about in Terry v. Ohio, the officer can pat you down. That's just in your pocket area. Can't go inside the pockets unless they identify something from the pat down. Or if the officer has probable cause to arrest you, the officer can search you without a warrant. All right. We're still going on. All right. Voluntarily waiving. So giving consent. So generally, officers will ask, hey, can I search you? If you give consent to have that officer search your car, search your house, search your person or your bag, whatever it may be, the officer doesn't need reasonable suspicion or probable cause. The officer has your consent. You have consented. However, you can take away that consent at any point. So now if you take away that consent and that officer has probable cause, then the officer obviously can keep searching. It doesn't matter if they have your consent. However, if they don't have probable cause, they can't keep searching. And obviously there can be no coercion or deception saying, for example, if you don't allow me to search you, I'm going to arrest all your family. So that is a type of coercion or deception officers can't do to search you and get consent. All right, the Fifth Amendment. This is really a misunderstood amendment. So it's what we call the pronged effect, and it was Miranda v. Arizona. That's a case you need to know. And it basically said that Miranda was arrested. Miranda did not understand his rights. He confessed to a crime. And so the Supreme Court said we now have the Miranda Rule, which basically says, and here's the prongs that a lot of people don't understand, that if a person is in police custody, not free to leave, so that's one of the prongs, and the police or the investigator is interrogating the suspect, that person, before they can answer any questions, has to be read Miranda. Miranda basically says, hey, you have the right to remain silent. Do you understand? You don't have to talk to me. Do you understand? You have a right to an attorney to represent you. Do you understand? If you can't afford one, we'll pay for it. The state will pay for it. Do you understand? And now, having known your rights, that you can remain silent and you can get an attorney, do you still want to talk to me? So, and why that's important is I'll hear a lot of people say, for example, an officer will pull somebody over. They just saw them go by speeding, doing 25 miles over this posted speed limit. So they're doing 50 in a 25-mile posted speed limit, and the person will say, you didn't read me Miranda. Well, the officer saw that person commit the crime. There's no questioning to be done. Now, if that officer kept that person wasn't free to leave, and that officer knew, for example, that person had a dead body of somebody they murdered in their trunk, and that officer was interrogating that person, trying to get them to admit that they murdered the person in their trunk, then they'd need Miranda. But just for running the stop sign, that person's already done it. The officer's already seen. If the officer doesn't, generally there's not going to be any questioning with that, so Miranda is not required. So just make sure that you really understand Miranda, because I think a lot of TV shows show the officers, when somebody's in handcuffs, just reading it off, and it's just not correct in a lot of things that I see out there. All right, now we have the 14th Amendment. And remember, I want you to remember these, so you need to know the first, the second, the fourth, the fifth, and now the 14th. It's often referred to as the Due Process Amendment. It provides that no state can deprive any person of life, liberty, or property without the due process of law. So evidence has to be presented in court. It's also the Equal Protection Clause that says that police cannot deny the protection of law to any group of persons by making unreasonable distinctions based on race, religion, gender, and national origin. All right, so let's go over some exclusions and things that can happen. So the Exclusionary Rule, which I want you to understand, is a judicially imposed requirement that any evidence obtained by the police using methods that violate an individual's constitutional rights be excluded in criminal prosecution against the individual. So, for example, fruits of the poisonous tree. There's a case we're going to talk about. It's the Mapp v. Ohio. And it's basically where the police went to a house. They knocked on the door. Mrs. Mapp said, you can't come in. You don't have a warrant. The officers went away, came back, forcibly entered, showed her a piece of paper, wouldn't give it to her, said this was a warrant, even though it really wasn't. And they ended up finding in a vehicle pornographic material, and they arrested from that. And that's called fruits of the poisonous tree. The officers didn't have a warrant to enter the premises. They entered illegally. They violated Mapp's Fourth Amendment rights. And so because that's fruits of the poisonous tree, because that means because their entry was illegal and poisonous, any evidence that they gained is thrown out. Here's another couple cases as well that you can pause here to read about. All right, now there are exceptions to the exclusionary rule, which means good faith. So if an officer is acting under good faith and does something under good faith, then they are protected. So for instance, there are cases like Hill versus California, where police went to Hill's apartment. The man who answered the door said he was not Hill. The police thought he was. So they went into the apartment. They found out later it really wasn't Hill. Gosh, it's confusing, right? Well, anyway, it basically says because the police, under good faith, really thought this person was Hill and was lying to them, the evidence that they obtained the search was covered because it's under good faith. Okay, we also have the inevitable discovery doctrine. So this allows for the admission of a legally obtained evidence if it would have been discovered legally as well. So the inevitable discovery doctrine basically says, so let's say the officers went into somebody's house without a warrant and they found a gun. And that gun was tested to find that it murdered 2 people. Well, if they didn't have a warrant, that's fruits of the poisonous tree. That gun is thrown out because the police didn't have a warrant and they violated the person's Fourth Amendment right when they entered the house. However, if you have, for example, somebody's boyfriend that comes forward and said, hey, she had a gun, I know she killed somebody and she keeps the gun in her apartment in this room, then the police could go up, say, I would have applied for a warrant. This judge would have granted it and we would have found the gun anyway. So that's called the inevitable discovery doctrine. I know, kind of confusing, huh? We also have the independent source doctrine that holds that a legally obtained evidence, again, if the officers search your house or your car and they don't have a warrant, that, again, if somebody else comes to them and says, just like I described, hey, this person did this, or you can find the gun here, that as long as the police didn't coerce that person or that person wasn't acting as an agent of the police, that evidence will be allowed. And here's another example, Murray versus U.S., of the independent source doctrine. So please pause and read this. All right, we also have exigent circumstances. So let's say that officers, I'll give you a crazy example, that officers are chasing somebody that has a rifle and is shooting at people running down the street, and the person runs into the house. The officers don't have to stop and go, we have to get a warrant because we can't violate that person's Fourth Amendment rights by going into this house. Well, because people's safety, citizens' safeties are at risk, and we have to be able to enter that house. And so the officers don't have to get a warrant. They're not violating the person's Fourth Amendment right because that person of their actions and what they're doing. For also, if police stop somebody and they find a drug on them, let's say heroin, and that person starts running from the cops and they run into a house, same thing. If the officers stopped and didn't go in the house until they got a warrant, that person, a reasonable person would think that person would probably flush the heroin down the toilet. That could destroy evidence. So because of that, that's exigent circumstances, that officers in hot pursuit. And so therefore it allows the officer to enter the building or the home or the car without a warrant. All right, let's go over from use of force. So there's different types of use of force. We have one force that's called less than lethal force. So that's force where officers use different kinds of arm bar holds or different positioning on somebody as far as containing them. Taser, pepper spray, the ASP baton. Then we have lethal or deadly force that may result in great bodily harm or death. So that's generally lethal force is with a firearm or a handgun. A lot of departments used to, some don't anymore, but this is just a good guide of what we consider the use of force continuum. So let's give an example. The suspect's actions always determine the level of resistance the officers use. So let's look at low level, the blue at the very bottom, and that contains the dark green, the light green, and the yellow. So if the suspect is compliant, the officer can just use the officer's presence, so just being there, can talk and use verbal communication, can use empty hand tactics, such as grabbing somebody's arm and escorting them to the vehicle, and they can handcuff or restrain. Now, if the suspect is being passive, the officer can do all of that and use their baton as an escort tool. See how we're adding? If the suspect is actively resisting, the officer can do everything they've done in the green and light green, and then they can add more things. So this just kind of shows you, it's just kind of a guide that officers utilize to what is approved. And like I said, not every department uses this, but it's a good guide to see how it's done. All right, there's other case that you need to know that's very important. It's called Tennessee versus Garner. And this was obviously in Tennessee. And before this case, officers were allowed to do this. There was a burglar that had burglarized a home. Officers responded. The burglar started running out of the house, running away from the officer. The officer said, "Stop, I'll shoot." The suspect did not stop, and the officer shot the suspect in the back, shot Garner in the back. And this went to the Supreme Court, and the Supreme Court said no. Unless that person is a serious risk, such as they're actively shooting people, officers can't shoot somebody in the back. So that's why Tennessee v. Garner is very huge. All right, that ends this presentation.